to have her testify. So, my lords, we respectfully submit that in the circumstances that we are faced with this particular holder of this particularly singular office that is supposed to make a determination that reflects the sovereign will of the voters of Ghana in an election, which is what democracy is all about. It is our respectful submission that that constitutional obligation cannot be set aside by subsidiary legislation or by reliance on subsidiary legislation. It cannot. Every legislation that we've talked about, CI 87, CI 47, and I mean, none of that can set aside the sacred public duty of this chairperson and the need to account for that public duty where the forum demands it. And my lords, this is a forum that demands it. My lords, reference has been made by my learned friend to the case of Armour versus hydrofoam. And that was indeed a Supreme Court decision in 2012. The decision read by Justice Baining and a court that comprised various justices, including your Lordship, the Chief Justice. Now, my Lord, that case has absolutely no application to the circumstances that we are dealing with. Because in that case, what happened was that the parties had agreed that instead of testifying by themselves, they would both rely on the testimony of an expert, a surveyor. And on appeal, the point was raised that the plaintiff himself ought to have testified and not rely on the evidence of the expert. Within that context, the parties had agreed that we're going to rely on an expert because this is a matter on which an expert can resolve the issue between us. We don't need to be sort of testifying and, we are not the expert. We'll rely on an expert. The parties had agreed that. Then they go to court and one party is more or less arguing that because the plaintiff did not testify, it should be held against him. My lords, of course, rejected that argument. And my lord made it clear that the issue agreed upon was the value of the land. The trial judge considered it required expert evidence to assist him to determine it. The parties appear to have agreed with that position taken by the trial judge. For apart from the fact that they did not challenge it, neither of them gave evidence by themselves. They all deferred to expert evidence. The plaintiff relied on the evidence of the expert nominated and appointed by the court with the party's consent. The defendant went further to call three other experts in land valuation. It is in that context that the Lordship said a party does not need to call evidence by himself. Where the issue is where the issue to be resolved is of such a nature that expert evidence would, I think it should be B, but here it says would the best evidence. I think B is missing from the report. Expert evidence would be the best evidence required to assist the tribunal of fact to resolve the issue, or where expert evidence is dispositive of the issue. That is what Hydrophone's case, Armour and Hydrophone, is about. That case has no application to the circumstances that we're dealing with here. The circumstances that we're dealing with here is of somebody who has elected to testify and who has notified of that election not only by submitting a witness statement, but also in affidavits that he has filed. Because, my Lord, if we didn't take her affidavit seriously, then it would almost be as if she is taunting us and saying, you know, I am prepared to give evidence. She's taunting us with that, and she's using that to get a decision in her favor on interrogatories. Once that decision is given, then she now says, no more, I'm not giving evidence. You said in opposition to an application for leave for interrogatories, you, the holder of that important constitutional office, you said, I am going to be available to be cross-examined. On that basis, among other things, their lordships have made a ruling allowing you not to have to answer interrogatories. Then, after you've got that decision, you now ignore the things that you said in your affidavits, and you come and your counsel is saying to the court, I'm not going to put you in the witness box. Obviously, the interrogatory process that we filed was meant to help us in the conduct of our case. And what they filed by way of witness statements and so on was again meant to help us in the conduct of our case. So once they filed and gave an indication that she was going to testify, and she herself gave that indication in her affidavits, my lords, our options in terms of her being called to account for a constitutional duty, our options were entirely non-existent. Our options were to calmly wait for her to come into the witness box for cross-examination. We had no other option. We had no other option, and we still have no other option, because it has not been said at any point to your lordships that they are not relying on that witness statement. It has not been said. Now, my lords, another decision was cited, I believe. Yes, this is the Akuno, Bafo, and Lawrence Boaku case. And my lords, part of the problem that I see in respect of what we are faced with is that on the one hand, they are saying that they are not making a submission of no case. Then on the other hand, they are talking about burden of proof. My lord, the burden of proof can only be relevant if we are talking about a submission of no case. Because otherwise, why are we discussing burden of proof? I mean, burden of proof has no relevance at this point. If all we are talking about is Order 36, Rule 4.3, and so on, burden of proof has absolutely no relevance. In any case, the authority that was cited, this Joseph, Aknu, Bafu, and Lawrence Waku, significantly, when counsel himself was reading from the passage that he read from, their lordships talked about the shifting of the evidential burden. The shifting of the burden, which depends on the stage that the case is at. And my lords, I'm really reluctant to go into the issue of burden of proof at this point because I think it's irrelevant. But because it has been raised, I'm obliged to point out why it is irrelevant. Because if your lordships look at the Evidence Act from Section 10, and my lords, I will not read those sections, but from Section 10 to Section 15, your lordships will see the differentiation between the burden of persuasion, the burden of adducing evidence. And my lords will know that in a case, the burden of proof can shift depending on this stage and depending on another stage. So if indeed they were making a submission of no case and we were having to respond, then we would, for instance, be able to demonstrate that as at where we are, you have to take the petitioner's case as true. You have to take the evidence of the petitioner as it is, without the benefit of the answer and whatever is going to be testified to by the. So if we were dealing with that matter in the context of a submission of no case, I would have clarity on how I would address your lordships on burden of proof. But they are saying to us that they are not dealing with burden of, they are not dealing with a submission of no case. And I believe your lordships have accepted that that is their position. Now, if that is their position, then my simple submission is that burden of proof has no relevance at this stage. And that what we should simply focus on at this stage is, if they decide to do a submission of no case later, that's another step. We'll cross that bridge when we get there. I never like to cross bridges before I get there. But my lords, at this stage, we are not dealing with matters of burden of proof. And so when we also have read to your lordships section 62(1), at the trial of an action, a witness can testify only if he is subject to the examination of all parties to the action, if they choose to attend and examine. If a witness who has testified is not available to be examined by all the parties to the action who choose to attend and examine, and the unavailability of the witness has not been caused by any party who seeks to cross-examine the witness, the court may in its discretion exclude the entire testimony or any part of the testimony as fairness requires. This is clearly a section that has nothing to do with why we're here. Because
I thought the court pointed this out and counsel accepted it. So let's I
did not have the impression that counsel accepted, because after the court made the reference, he made a further reference to section 60, because that's why he went on to say we do not require any further evidence in this matter. He went on in my notes, unless I didn't hear him. And that is what led him also to the citation of the cases that he sought to. Now, my lords, there's been a suggestion petitioner cannot compel us to enter the witness box. My lords, We are not saying, we are not actually compelling. It is indeed their election. And we are saying that they have made the election. So it is not our compelling them, but they have made the election and they must stand by it unless they clearly and unreservedly give a contrary indication. Now, my lords, it was also suggested that, this was by reference to the English civil procedure rules. It was also suggested that the drafters of the drafters of CI 41 and CI 87 made some choices differently from the English civil procedure rules. Of course, we are a sovereign country and our statutory regulations are made by our own rules of court committee and so on and so forth. But my lords, we cannot put English civil procedure rules against our rules and say that our rules of court committee drew inspiration from this, and we try to compare the two and say that therefore we should interpret ours differently. My lord, that respectfully is not an appropriate way to interpret our own rules. Our rules, CI 47 and 87, as I have gone through, our rules make provision for what they make provision for. And you cannot come and say that the word timeously does not appear in our rules. It appears in the English rules, and therefore there was a reason why they did not include timeously in our rules. My lords, that with the greatest respect, is not a process that your lordships should use for interpreting our subsidiary legislation. Our subsidiary legislation is in its own terms, and I have read the terms of that subsidiary legislation and their applicability here. So nothing in those English rules, nothing can be relevant. And indeed, it is also my submission, that in fact, as I indicated even yesterday, it's also my submission that in this particular matter of an election petition, it has not been demonstrated that what they seek to do is in compliance with CI 99 or CI 47 or CI 87. It has not been demonstrated that there is compliance with any of those. They have stated clearly that this is not a submission of no case. They have stated that clearly. And they have stated clearly that the only basis for their submissions is Order 36, Rule 4, 3, and CI 87, the rules that we have discussed. If their application does not fall squarely within those rules, my respectful submission is that it ought not to be countenanced. If they want to come back and say that they are not relying on the witness statement of the first respondent, for instance, if they want to come back and state that, that needs to be stated clearly, because then our options will also become clear. That is my submission.
Let's hear you.
Yes. My lords, on point of law, lords, I wish to, with your kind permission, read the Rule 3C of CI 87. Lords, it says that a witness statement, yes, my lords, a witness statement shall be verified by a statement of truth. Nowhere does the rule say that the witness statement shall be sworn, as was submitted. Lords, secondly,
it was a question from the bench to counsel that a witness statement per se is not evidence, and it is not also an affidavit. And I think there was concession.
There is a statement of truth attached to it, and that's what this is saying. My lord, secondly, it is my submission that the petitioner, the counsel, cannot approbate and reprobate regarding Rule 3E. Lords, previously in the proceedings before the court, Lords, the proceedings of 29th of January at page 40. Yes, my lords, at page 40 and 41. This is what counsel said when counsel for the second respondent was trying to put issues from his witness statement to the witness. He says, that witness statement is not yet in evidence. It has not been adopted in evidence. My lords, with respect, the proceedings are being confused. And lords, at page 41, he says, my lords, with the greatest respect, what he is showing the witness was an attachment to the witness statement that has not yet been adopted. Very different. So, my lords, it's my submission that...
My lords, respectfully, I cannot be misrepresented. I made it clear that I was talking about the election to adduce evidence. I think I made it very clear.
Lord, so it's my submission that Rule 3E, all the provisions are quite very clear, and my learned friends putting one interpretation on it on one day and another interpretation on it on another day is most unfortunate. Respectfully submitted.
My lords, may we repeat from the onset that this is not a submission of no case that we are seeking to address. Secondly, that there's nowhere in CI 47 or CI 74, 87, where provision is made for submission of no case in a civil matter, and yet it is done. Now, my lords, the fundamental error with counsel's submission, in my view, is that the submission is secular, and I'll proceed. It's secular. The arguments are secular. Secular, not sequitous.
Sequitious. They want you to use sequitious.
No. My life, I choose secular.
Is that CIRCULAR?
Yes. My lordship will see that Rule 3D says that where a witness statement for use at a trial is not served in respect of an intended witness within the time specified, the witness shall not be called to give oral evidence unless the court grants leave. Then 3E1 says, if a party has served a witness statement and that party wishes to rely at the trial on the evidence of the witness who made the statement, the party shall call, and I want to emphasize that word, shall call the witness to give oral evidence unless the court orders otherwise, or that party puts the statement in as hearsay evidence. My lords, one will see from a construction of this sub-rule that a party must first serve the witness statement. He must file and serve. And that statement, when he serves the witness statement, no, my lords. Yes. Yes, but it's a legal matter I'm advancing, and counsel for the petitioner has been. Yes. My lord, my point is that from the words of 3E, the party must have served the witness statement first before he relies on it subsequently. So the argument that counsel for petitioner seeks to make, that service of the witness statement means an election, is inconsistent with the provisions of 3E. Because 3E says that you will serve, and then you must state you rely on. So the two cannot be mixed together. Now, my lords, again, the court will notice that the words are, if the party wishes to rely at trial, then he shall call the witness. So, saying that I'm calling a witness is what indicates that you are relying on the witness statement. So when we say that we do not intend to adduce evidence, it means we are telling you that we do not intend to call any witness, which means that we do not intend to rely on our witness statement. So my lords, that's the sense in which the argument is secular. He cannot say that the witness statement has been served, and therefore you are elected. It cannot be the case, reading from the text of the law. Then again, my lords, if your lordships are to look at the, then again, yes, it says, where a witness is called to give oral evidence, that is 3E sub 2. Where a witness is called to give oral evidence under sub rule 1, the witness statement of that witness shall, and he was emphasizing on the shall, that it is an obligatory thing. But that will only happen when he is called to give oral evidence. The shall will not apply when the witness is not called to give oral evidence. And then again, sub-rule 5 states that if the party who has served a witness statement, again you see the distinction between serving a witness statement and electing, does not call the witness, that means that the rules recognize a situation where you serve a witness statement but you elect not to call a witness. Does not call the witness to give evidence at trial or put the witness statement in as hearsay evidence. Any other party may put the witness statement as hearsay evidence. My lords, therefore, we submit that a proper analysis of these provisions makes it very, very clear that the service of a witness statement is not an election to rely on it, or to give evidence. My lords, I will now look at the Sumala building case and say that in that case,
Yes.
No, he cited it. Yes. 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 He responded to it, and I'm replying to his response. Legal, it's legal.
Give a twist.
Yes. My Lord, Your Lordship will note that in that case, the Sumala actually filed an affidavit in which he admitted to a fundamental matter in issue, namely that he had a British passport. That was the basis for the court saying that then you bear the burden of adducing evidence to explain how, if you had a British passport, you are still saying that you are entitled to be elected as a member of parliament. So it is a completely different situation from an affidavit which is saying that we do not agree with the interrogatories because in any event, when or if the occasion for cross-examination arises, you have the opportunity of cross-examining them. Yes, so my lords, that does not mean that the petitioner is committing herself to the first respondent is committing itself at all costs to lead evidence such that he may have to come out to the court to seek leave not to give evidence. My lords, now my lords will see that the issues set down for trial are five. And my lords, all of them deal with whether or not the second respondent crossed the 50 plus